Now, the prosecution of Donald Trump will be the first such trial in the history of the United States criminal justice system. Let that sink in. But how will the former president's lawyers handle his case? Former federal prosecutor Scott Fredericksen joins us now to speak about some of the potential pathways ahead for the former president. It's great to have you with us, Scott. Spell out for us, as you see it, based on the allegations made in the indictment, what options or holes the president's legal team has or may point in the case against him.
Sure. Well, this indictment is a very strong indictment. It spells out fairly overwhelming evidence. So some of the options available for the defense here are conventional and others are not conventional. So conventional first. You'll see Judge Cannon will set a schedule for filing motions to dismiss. So they'll attack the indictment. They'll, as you've heard Trump and his spokespeople say, they're going to say he was treated unfairly. Why aren't others prosecuted? They're going to make constitutional challenges. None of those are going to be successful. There's not any legitimate basis for those. Nothing has been reported to indicate that would support that kind of motion. What they'll do also is file motions to suppress the evidence. Most importantly, they want to suppress the evidence that comes from Trump's own attorney, Evan Corcoran. If you recall, a judge here in Washington, D.C., federal court, the chief judge, issued an order allowing the attorney-client privilege to be pierced on the crime fraud exception. And so in the indictment, we see the actual words of his own attorney reporting the directions from the former president, suggesting that he not produce documents, that he destroy documents, as well as the other activities he's done. It's unlikely that motion to suppress will succeed either. This was a decision by the chief judge of the federal court here in Washington, so the prosecutors had ample basis to proceed there. Unconventional approaches. First of all, they want to delay this trial as long as possible in the hopes that the former president becomes the next president. And if so, he'll quickly pardon himself or appoint an attorney general who would quickly dismiss this case. If they have to go to trial, and they don't want to go to trial in this case because it's a very strong case, they do have a couple things in their favor. One, they have a favorable draw on a judge who has issued an unusual ruling before in favor of the former president, which was slapped down in an embarrassing fashion by the 11th Circuit Court of Appeals, a very conservative appellate court with two of those judges appointed by Mr. Trump. Now, if they do get to trial, though, the other thing in their favor is they have a good potential jury pool with a significant number of potential jurors who are likely to be Trump supporters, or at least very sympathetic. Their goal, the Trump team, is to persuade just one, more if possible, but just one juror not to convict the president and turn that into what would be a mistrial, and expect then that the Department of Justice would not try him again. All they need is one juror to hold out.
It's fascinating to hear you break that all down, Scott, because there are potential avenues that may work in the former president's favor. But even, 24 hours after seeing this all laid out, it still takes a while to absorb the severity of not just the case that the prosecution is making, the special counsel, but the evidence that it's pointing to is President Trump's own lawyers, his conversations with his lawyers. So what, in your view, should his legal team be most concerned about?
Most concerned about is trying to suppress that evidence from his own lawyers. I mean, there's evidence in there that he has Walt Nauta hiding boxes on video.
Right.
So his own lawyer won't know what to report to the DOJ. He's misleading his own lawyer. We have a transcript where his own lawyer is being told, hey, what if we just tell him we don't have these documents? I mean, the former president, it sounds like a mob boss there. And that is the kind of thing he's suggesting. Why don't you take these documents? And as his own lawyer describes, he makes a motion like, which he interpreted, his own attorney interpreted as, destroy those documents. So, what this case is about is not just these highly classified documents that would be, a real threat to our defense if our enemies came into possession of those. I mean, so you have that, but it's the obstruction of justice. It's the conspiring to create a false statement and certifying to the Department of Justice, you've got all my documents, when in fact they didn't have those documents, and they have pictures of all those documents that there when that certification is made. So they've got to somehow try and suppress that evidence. That's not going to happen. The government was extremely careful as well as thorough in gathering this evidence. That's why this indictment, which is very specific, lays it all out.
Yeah, it's a good gut check on how not just serious the allegations are, but how extensive the evidence appears to be. And this is just one case against the former president. Scott Fredericksen, great to have you on this topic with us today. Appreciate it.